Council, we're ready whenever you are. Make sure you're
Morning,
not muted.
Good morning, Your Honors. May it please the court. My name is Max Pomerantz and I represent the appellant YH Soul Holdings LLC. I respectfully request 5 minutes for rebuttal.
All righty.
Thank you. This morning, I'll be addressing the abuse of discretion by the lower court in denying an appellant's motion to vacate the default, as well as the lower court final judgment being void and moving to attorney's fees and costs. Your Honors, YH Soul Holdings respectfully requests that this court reverse the 6th Judicial Circuit Court's ruling. First, regarding the denial of appellant's motion to vacate, the lower court abused their discretion in denying YH Soul Holdings' verified motion to vacate the default judgment. According to Florida Rules of Civil Procedure, Rule 1.540B, it requires a party seeking to set aside a default judgment to meet 3 prongs. The first, that the failure to file a responsive pleading was the result of excusable neglect. 2, that the moving party has a meritorious defense. And 3, that it acted with due diligence in seeking relief from the default. The facts of this case, in the case at hand, LW is a legal assistant whose duties consisted of receiving mail and emails, calendaring dates, placing holds on files, placing items received into the firm file for a given client.
Yeah, but here's the thing is, I think we all know the law is really pretty clear on this. I mean, the law is not going to cut a lawyer's employee a break. The law is holding the lawyer responsible for anything their employees do. And what's troublesome about your case is a number of things. But the things that concern me is that a motion for default was served on August the 14th of 2018. The order entering the default was served on the appellant on October 24th of 2018. And then the motion to set aside the default wasn't filed until February 19th of 19. I mean, there was a long period of time. And then the original order denying the motion that you filed told you to answer within 20 days. So you've had 4 specific warnings by the court, or at least on notice. And that's what's so I mean, I hate these kind of cases. I don't like to see defaults entered. And I don't like to see, you know, a court basically not setting aside a default. I mean, that pains me. I mean, you know, I practiced law a long time. I can put myself in that situation. It can happen to any of us. You know, and I always like to think that the courts will, you know, lean on giving everybody their day in court. But in this case, you had milestone after milestone after milestone. It's really, really hard to find excusable neglect here. And I'm the kind of guy that would look for it under every rock. I'm going to tell you right now, I would. It's hard in this case because you have all of these milestones. Somebody should have been clued in at some point. Okay. I mean, that's a tough part about your case.
Your Honor, I'd like to point your attention to Elliott v. Aurora. It's a 4th DCA case where the court specifically defined excusable neglect, where inactions result from a clerical or secretarial error, reasonable misunderstanding, a system gone awry, or any of the other foibles of life to which human nature is heir. And that's simply what occurred here. As part of—
How about the other 4 incidences?
Sure.
The order denying says you got 20 days to answer. The motion for default filed by your opponent in August. The order took 2 months, 3 months, filed in October. You don't get around to filing a motion to set aside until February of the following year. I mean, it's just, you know, it's hard to sort of look at this and say, I feel sorry for these people, because everybody was asleep at the switch for milestone after milestone after milestone.
Well, Your Honor, getting back to the facts of the case, which will help answer your question, as part of his ordinary practice, the legal assistant received and reviewed the order dated July 18, 2018, and line 3 read as follows. It said, defendant's motion to stay as to all defendants other than YH Soul Holdings LLC is denied. And LW, the legal assistant—
It's a confusing title for sure.
Yes.
You know, no question about that.
And
except that it was your motion to begin with.
Yeah, true.
It was your motion to stay.
And I think it was a stipulated order, if I recall, too.
And that was after you had already defaulted once.
Yes, it was an agreed order. But at this particular instance, where the facts lead to what happened here is LW inputted the hold on the case in the system of the law office's system and put a hold on the file as he believed the file was stayed, reading the confusing languages we've all just seen. And
Well, but
at
what
that-
does that mean? Because you're all pointing to LW's actions as the neglect, but why isn't the neglect that of the lawyer who knew what was going on in the case, who knew that he would be expected to file an answer within 20 days? Where was that lawyer?
Your Honor,
Where was the lawyer? Where's his excusable neglect?
the lawyer was checking the calendar, the lawyer was checking the file, and all that popped up on the file was that there was a hold, and the calendar for that particular case was attached to the file. And so the lawyer couldn't see anything regarding that because there was a hold on the case for an apparent stay that was seemingly a clerical error from a legal assistant of the firm. It was up until the point, to address Your Honor's question of previous, of February 18th of President's Day, where the attorney on the matter preparing for trials or upcoming trials saw in the calendar, the trial calendar, that there was this case coming up for trial, clicked into the file to see if there was any witness or exhibit list needing to be filed. And at that point realized and went through the case and saw, wow, there's a default judgment. And at that point, exercised extreme due diligence in timely filing a response and a verified motion to vacate the default judgment.
So after forgetting about the case basically for 8 months, the lawyer suddenly exercised extreme due diligence. And that's really what it comes down to. It's not so much the actions of the legal assistant. There was a lawyer who was actively involved in this, who filed a motion, who submitted an agreed upon order, and then forgot about the case.
There was, to address Your Honor's question, there was also no, in the meantime, meet and confers between the parties. There was no real communication between the party on the plaintiff side as well. By putting the hold on the case, essentially, every incoming mail or email or order that came in subsequent to that was placed into the file dutifully, but the file was just on hold.
And nobody trained the legal assistant that if a motion for default, and then God forbid an order for default, an order granting a default comes in, that, oh, I'll just toss that in the file and someone will get around to it because there's a hold. I mean, at some point, isn't there a failure to train?
At this stage, I can tell you that for the firm, does a monthly check of all cases every 30 days. And even if there is a stay or a hold, everything is gone through in order to correct such actions. But here, the legal assistant didn't willfully or intentionally refuse to act in this manner. And
Oh, there's no question about it. He made an honest mistake. I mean, there's no issue there. I'm not, there's nothing to suggest otherwise. You know, I mean, I'm not going to micromanage what you all do, but unfortunately, lawyers really need to stay involved in cases as much as we all want to give up to somebody else to manage it. Just this kind of stuff happens, unfortunately.
Yes, to address your Honor's question or your Honor's statement, in Elliott v. Aurora, this just happens to be one of those foibles of human error on the legal assistant's part. And upon realizing it, there was immediate action taken. I believe there's case law, significant case law talking about.
I don't see immediate action here. That's been my concern. That's why I laid out all those dates for you. It's not immediate. I mean, like I said, I practiced law for a long time. I know what immediate is. If this happened to me, I wouldn't sleep until I got this thing handled. It would be filed. I would walk it down to court the next day. None of that happened here. It just months pass. It's like nobody's really worried about this.
Your Honor, in the Elliott v. Aurora case, I believe the default in that case was entered on May 1st, or a default judgment entered May 1st, and then it took until August 27th for the party to realize that there was a default. And upon noticing the default or discovery of the default is where the due diligence in seeking relief really begins. And it's the timeliness at that point to correct such action.
Well, the motion for default motion for judicial default was served on you on August 14th of 18. How could you not know that bad stuff is now happening?
Your Honor, it was received by the legal assistant and placed into the file with a hold, and
Well,
the
that's
system that
just
was,
not a good
Well-
answer. That's just not a good answer. I'm sorry. You know, I wish it was. I wish I could say, okay, I get it. It's just not a good answer.
well, to address your question of previous and bringing up the dates, when it was discovered on the 18th of February, a verified motion was filed on the 19th of February, whereas case law has shown that it can be held anywhere between 6 to 15 days between the discovery of a default and the filing of a motion to vacate that default shows due diligence. In fact, there's 2 second DCA cases, Allstate
Well,
Floridian.
I think the facts of this case show that there is not due diligence in organizing your office. That's what it shows, unfortunately. Okay. And that falls on the responsibility of the lawyers.
Okay, Your Honor, in this case, although your question points to the responsibility of the lawyer, the legal assistant and the system put in place allowed it so that any lawyer scrolling through this wouldn't be able to see it, and all communications went through this legal assistant. So it almost prevented itself from reaching the hands of a lawyer in order to do something about it.
It's a bad setup. That's a dangerous setup, and that's on the lawyers again, you know.
And it has changed, the system has changed and has been corrected to account for such actions, especially today. But in regards to Rule 1.540B, the excusable neglect is clearly the human error here by the legal assistant. I'd like to point to the meritorious defense, where Fortune Insurance Co. v. Sanchez talks about a meritorious defense is established where a proposed answer is attached to its motion to vacate, and which answer sets out in detail a number of affirmative defenses. Here, there was the excusable neglect. The proposed answer and affirmative defenses was filed in an abundance of caution, along with the verified motion to vacate the default judgment. And all 3 prongs of Rule 1.540B seemingly were met. The fault here lied in a reasonable misunderstanding of an order, which led to a default. And therefore, the final judgment entering of a default should be vacated and this matter be reversed and
Okay,
remanded.
thank you, sir. Thank you. Mr. Blackmore?
Yes, good morning, Your Honors. Jonathan Blackmore on behalf of the appellee. Your Honors, in this case, there's been a complete and utter absence of any demonstration of an abuse of discretion by the trial court in denying the motion to vacate default. I think the purpose of the default, which is pursuant to case law, to speed the cause of action and to prevent a dilatory or procrastinating defendant from impeding the party in the establishment of this claim, was served. And the record in this case established the neglect of the defendant and the complete and utter absence of any excusable neglect or due diligence in moving to set aside the default. Your Honor has pointed to the timeline. Previously, the agreed order was entered July 18, 2018. And this order itself was predicated on the defendant's own motion, which never requested that a stay be entered as to the defendant in the first place. And number 2, the order itself clearly and unambiguously provided that the defendant, by its own agreement, was going to file an answer to the complaint within 20 days. No action was taken thereafter to comply with that court order. On August 14, 2018, a motion for default was filed. On September 26, 2018, there was actually a notice of hearing. The notice of hearing itself is not in the record, but it's evidenced on the case abstract filing report on the docket in the record that there was a hearing, a notice of hearing for October 24, 2018. On October 24, 2018, the order of default was entered. The language of the order is indicative that a hearing was held on that motion. The order was served pursuant to a certificate of service that same day. On December 5th, 2018, there was an order setting trial, and you don't have until February 19, 2019 to the point in which the motion to vacate default was actually filed. So there was a gap from July 18, 2018, when the order was entered requiring an answer within 20 days, until February 19, 2019, the actual filing of the motion to vacate default. The claim of excusable neglect is simply not excusable neglect under any reasonable interpretation.
Mr. Blackmore,
Andrew.
this comment probably is irrelevant, but unfortunately, when I look at a case like this, I'm reminded of a time when lawyers used to work together. Somebody overlooked and made a mistake, they'd pick up a phone and say, hey, did you know you needed to file something? I realize that that ship has sailed. We don't live in that world anymore, but this case saddens me because we don't live in that world anymore. And every once in a while, I'm going to run into a lawyer going forward who is going to demonstrate that they understand that we're a profession that's supposed to work together to get things done for our clients. And I'm going to appreciate that. But that didn't exist in this case. And that's irrelevant. I realize it, but I had to make that comment.
I appreciate the court's comment. I can't say that it did or it didn't take place because I didn't handle, my firm didn't handle the events in the trial court leading up to the entry of the appeal. And the record doesn't speak to anything else that happened with regard to any extrajudicial communications between the attorneys prior to the default. But what clearly the record does show is that every opportunity for the defendant to participate in the case and to prevent the default from being entered was provided. And that is evidenced by the order itself, which was agreed to and provided the 20 days. And the defendant was obviously aware of that order. They agreed to it in the first place. It was predicated on the defendant's own motion. And there was the application for default, and the default wasn't entered until months later. And even following that, there was no request to undo the default for a period of 4 months until the default was entered. So we did have, notwithstanding any other communications between the parties, there was certainly more than fair opportunity to allow the defendant to participate in the case and to comply with the order to file an answer prior to the default being entered. The purported excusable neglect is simply not excusable neglect. We have what amounts to a non-lawyer making his own call on whether or not an order operates as a stay, which is in effect a non-attorney applying his own legal interpretation of the law to the facts of the case, which amounts to a non-lawyer practicing law in effect. You have one portion of the order which may have some confusing language regarding the stay or the entry of a stay or non-entry of stay, but in the very same order, you also have a very clear portion which states that the defendant is required to file an answer within 20 days. The defendant's legal assistant should not be in a position to unilaterally make that judgment that this order itself can be disregarded, or the portion of the order which requires the filing of an answer can be disregarded because of his own faulty or improper legal interpretation regarding a separate part of the order. The case law in Florida is that ignorance of the law and failure to understand consequences are not excusable neglect. And the Spencer v. Vero case says that, as well as the case cited by Mr. Pomerantz of Elliott v. Aurora Loan Services says that as well. Failure to understand consequences and ignorance of the law is not excusable neglect. And that's exactly what
But sir, isn't there also case law that says that a systemic failure such as this could be excusable neglect?
Yes, I think there's plenty of case law that generally provides that a system gone awry can amount to excusable neglect, but
why isn't this more like a system gone awry?
Well, because there's a reasonableness aspect to those cases, and there's a reasonableness aspect to the interpretation or whether or not it's a close call in terms of whether there's been excusable neglect. For example, failing to calendar a deadline, putting an order or mishandling an order, putting the order in a drawer and forgetting about it. That's one thing, but the facts of this case simply are not reasonable in terms of having a normal, proper system in place that simply wasn't followed. This is, I think your honors
Well,
pointed
it
out.
sounds like maybe
This is a bad system, and the facts simply don't support that there's a reasonable mistake here that amounted to a failure to comply with this order. I'm sorry, I didn't mean to cut your honor off.
No, it's hard with the lag. I mean, I think there could be an argument that the system failed.
Well, I think there would have to be, it would have to be a reasonable system in the first place, a system that allows, that delegates that kind of authority, the attorney's job, to a non-lawyer, to then have that non-lawyer unilaterally determine that the case is on hold and therefore nothing else in the case, not the motion for default, not apparently notice of hearing, an order of default, an order setting trial, none of that needs to be forwarded on to the attorney for review, is simply not a reasonable argument for excusable neglect based upon a system going awry.
So then really I want to make sure I understand the essence of that part of your argument is that it could be a systemic failure, but it has to be a reasonable system to start with. And this system was not reasonable because it delegated lawyer functions to a non-lawyer. Is that what you're arguing, sir?
I think that's accurate. And
well, that is an accurate recitation of your argument.
That's an accurate recitation of a portion of my argument. Yes.
Okay. Yeah. Well, I said a portion.
Yes, correct.
Yeah.
And
okay.
so,
thank you. I just want to make sure I got it.
And I think there also has to be a reasonableness aspect to the explanation for the failure to take action for such a long period of time. And in this case, the explanation is illogical and therefore not reasonable. Again, you have an agreed order. The agreed order is predicated on the defendant's own motion. That motion never requested a stay be entered as to the defendant. So the purported confusion, frankly, it makes no sense. Again, the order also was agreed and provided the defendant shall file an answer within 20 days. All the while the legal assistant purportedly believes the case is on hold, it's obviously not on hold. The case never stops proceeding after.
As far as the lawyer knew, that motion was still pending, right? Or the agreed upon order hadn't been entered, right?
Well, the agreed upon order was entered July 18th, and so they would have been aware that it was entered. There's no explanation that I guess that the order, unless the legal assistant was also agreeing to the order without informing the attorney, but that's not in the record. It's hard to believe they weren't aware of the order. I don't believe they said they weren't aware of the order either in the lower court. So it simply defies common sense and logic that they were confused by this order and believed the case was on stay, whereby for a period of months, there's an unceasing activity in the case, including the application for default, the entry of default, and the entry of an order setting trial. And the order setting trial was entered in the beginning of December, yet the motion to vacate default was not filed until February 19th, when the explanation was that the attorney was reviewing court dates and then immediately filed the motion, but the court date would have actually have been set over 2 months earlier to that date. Again, ignorance of the law and failure to understand consequences are not excusable neglect. Erroneously believing that you're not required to take action in a case, you're not required to file something after an order has been entered, you're not required to file something to prevent a default from being entered, you're not required to move to set aside the default after having that default for 4 months between the date of the default and the date of the motion. This is not excusable neglect, and certainly not due diligence either. given this vast space of time. The final argument, the appellant also states that the final judgment is void for lack of notice. However, as this court had noted in the Rodriguez versus Thompson case, which I cited as 235 Southern 3rd 986 from 2017. In this case, the judgment is not void because the defendants received notice of the trial. There was an order setting trial. They were served with that order. Whether or not they appeared at that trial is unclear. There's nothing in the record that shows one way or the other, but they clearly had notice of the trial, and the final judgment was entered following trial. And therefore, the final judgment is not void, could not be void, because they had notice in comparison to the Rodriguez versus Thompson case, where this court stated that a judgment awarding unliquidating damages to a defaulted party after trial, which the defaulted party did not have notice, is void. That concludes my argument, and I'm happy to answer any other questions the court may have.
All right, thank you. Mr. Pomerantz?
Yes. To briefly respond, the system worked that we had at the firm for all other matters. Foreclosure cases are fairly similar to one another. Bankruptcies and stays regularly occur in foreclosure matters, where the case is usually frozen until a document comes in to lift a stay or a dismissal.
So a lawyer isn't even notified that a stay has been imposed? Order imposing the stay isn't forwarded, just nothing, everything just gets placed in the file from that point on?
I'm having a little trouble hearing you.
So no lawyer saw the order supposedly imposing the stay?
The order was put into the file, but the file was put on hold in the system, and so essentially it wasn't able to be viewed. But here, the stay remained, and the monthly review showed the stay. Now stays are looked after behind every 30 days. What you have here is an example of reasonable instance of a system gone awry. Not only is
the monthly review. The monthly review was in place at that time, or that's something that's happened subsequently? Yes,
it was at that time.
Okay, so who reviews the monthly list of stays?
There was an attorney who goes through each of the cases, and when you look at the case and you see that there's a hold on it, you can't really go through the files. And so at that point, just like where, for instance, a bankruptcy can last up to 2 years, it would just seem that every 30 days, the stay was still there. And so the attorney went to the next case.
Are you saying they're locked out? They can't actually go in and look at it?
Instance of a system gone awry. We have
no, wait, I'm sorry.
Firm, which has well over 2,000.
I asked a question. You said they can't go in and look at it if there's a stay. Are you saying they're locked out?
They are able to now. I apologize, my internet connection is a little unstable. They are able to look now. Back then as well.
So back then they could not look?
Yes, they could.
Okay.
But now it's required.
Okay.
The firm has well over 2,000 cases, and so the system is known to work. It was not a legal assistant practicing law and then delegating to a non-lawyer. It was human error and a system gone awry. We have all the elements met to have vacated the default. And should Your Honors find that the final judgment be vacated in this matter and the matter be reversed, then Your Honor should also find that the final judgment be vacated as void. Here, whether there was notice or not, there was not an opportunity to be heard based on the default and the default judgment. And due to the lower court's abuse of discretion, the lower court violated the appellant's due process rights, and as a result, the final judgment should be vacated as void. At this time, in addition to the relief being sought, avoiding the final judgment and reversing and remanding the case, the appellant is also requesting attorney's fees and costs in the matter. For these reasons, we respectfully ask this court to reverse the Sixth Circuit Court's ruling. Thank you, Your Honors.
Okay, thank you both. Our next case this morning is Lifsey Real Estate Holdings versus Victory Lofts at Channelside.